Good morning, everyone.
Hey, good morning, Hannah. I can see you.
Thank you for joining us today. We will be starting shortly at 11 a.m. And for those who are here early, thank you for waiting patiently. While you're waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with a vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Today's talk will be how should contractors in the construction industry manage the problems arising from COVID-19 MCO. This is a part 2 of our talk yesterday, and today we will focus on answering questions as well as an interview with John Wong from Charlton Martin Consultants. Before we start, let me introduce the firm and what we do. We are a firm trusted by small, medium enterprises, family businesses, and individuals. We were established in 1985, by Dato' MahWengKwai, a former Court of Appeal judge who is now a consultant with the firm. We're a medium-sized law firm with 22 lawyers and 24 staff. We're a full-service law firm with 4 departments: corporate, dispute resolution, employment, individuals, and families. We have 5 practice groups: ASEAN China Desk, construction, foreign direct investment, real estate, sports, and esports. And now on to introduce our online talks. In light of recent circumstance, we have decided to take our usually public talks held in our firm and decided to switch it online. And the purpose we do it is to share knowledge, raise awareness, and encourage networking. We do it for our clients, our potential clients, and in-house counsel. Yesterday was part 1 of today's talk, And today we will touch on answers to yesterday's questions and 10 questions on how to protect your interests from the effects of MCO. This will be the interview questions with John Wong. Please visit our website at www.MahWengKwai.com for more information, to read our articles, and to sign up for future talks. Next, allow me to introduce our speaker and guest speakers for today. Christine To is a partner in Dispute Resolution Department in MahWengKwai & Associates. She holds a double degree in accountancy as well as law from Monash University and UOL. She was called to the Malaysian bar in 2014. She is a chartered accountant as well as a certified adjudicator and paneled with the Asian International Arbitration Center. Her primary areas of practice are construction adjudication, arbitration and litigation, taxation, family law, and contractual disputes. Our guest speaker today is Mr. John Wong. He is the director at Charlton Martin Consultants. It's a construction contracts consultant firm. He has also a double degree in quantity surveying and in law. He's a member of the Royal Institution of Surveyors Malaysia, certified adjudicator, also empaneled with the Asian International Arbitration Center, and a fellow of the Chartered Institute of Arbitrator. He's experienced in oil and gas, commercial residential, utilities, infrastructure, power, and transportation sectors. He's also experienced as expert witness in court and arbitration proceedings. He's also presided over numerous arbitrations and adjudications and speaker, and as well as an established speaker and trainer. Without further ado, I will pass the time now to Christine. Christine, over to you.
Before I start, I would like to welcome everyone on behalf of the firm. Thank you for joining us today again. And we will now, as Hannah has pointed out, there's a two-part to this presentation today. The first part will be me taking on the questions that we received yesterday. And the second part will be my interview with Mr. John Wong. First of all, thank you very much for all the questions. We received overwhelming numbers of questions yesterday from Slido, and thank you very much for your enthusiasm. And because of a constraint of time, I've selected a couple of, I think, close to 13 questions to answer. And I hope that some of the questions overlapped, and we have actually modified some of the questions so to incorporate a few questions into one. Now I'll move on to the first question. What does the IEM form of contract say about EOT and claim for loss and expenses due to force majeure? First of all, as I have explained yesterday, force majeure by itself there is no legal definition. So the key point, the first thing first is that you must make sure that there is a force majeure clause in your contract. So this is the IEM form in relation to the extension of time. So clause 44 listed 5 events where where the contractor may apply for an extension of time. Number 1, any variation instructed under clause 51. B, any circumstances or occurrence entitling the contractor to an extended date for completion by reason of an express provision of the contract. The occurrence of an employer's risk or a combination of these risks. The relocation of any buried services or or main which are not shown on the drawings, or any act of prevention or breach of contract by the employer. At one glance, there is no mention of force majeure. I think that the relevant event that we can look at is under clause C, the occurrence of an employer's risk. So this is what was defined under IEM as employer's risk under clause 20.4. The following are the employer risks. A, war, irrespective of if the war is declared or not, or hostilities, invasion, and act of foreign enemies. B, act of terrorism. C, riots other than caused by the contractor's own employees and those of his subcontractors. Commotions or disorder or civil war. Any operation of the forces or nature which an experienced contractor could not have reasonably foreseen or priced for. Again, there's no mention of force majeure. However, if we look at clause D, any operation of the forces or nature which an experienced contractor could not have reasonably foreseen or priced for. Arguably, this situation that we have today, being the COVID-19 MCO, whether it falls under sub D, and in particular, any operation of nature which an experienced contractor could not have been reasonably foreseen or priced for. So I have looked at that. There is what it means by forces of nature was not defined in IEM. So what I did, I looked at the Cambridge Dictionary, what is defined as nature, and it reads, all the animals, plants, rocks, etc. in the world, and all the features, forces, and processes that happen or exist independently of people, such as the weather, the sea, mountain, the production of young animals or plants, and growth. However, there's no mention of what we have here today in respect of the coronavirus of that nature. So arguably, we can try under D, if the engineer is with us, is with the contractor, that this event we have here, the COVID-19 MCO, falls under the employer's risk, then what happened next? So let's talk about the issue of time and cost. Clause 20.3 deals with both of them. 20.3 sub 1 deals with the cost aspect of it. Let me read out. If the damage or loss is caused by an employer's risk or a combination of such risks, the contractor must make good such damage or loss to the extent instructed by the engineer. And the additional costs for the making good of such risks are to be certified by the engineer under clause 53. So there is a room for the claim for loss and expenses under IEM. Whereas for time, let's look at sub 2. If damage or loss to the works and their making good have caused delay to the works beyond the date for completion of the works, the engineer must take such delay into consideration in determining any extended date for completion which the contractor may be entitled under clause 44. Clause 44 is the clause that we have just looked at, this particular clause, extended date of completion. So to answer that question, if arguably this COVID-19 MCO may be an employer's risk under the IM. If that is the position, then we can utilize 20.3 to claim for both cost and time. And just to address this particular question, forced merger was not mentioned in the IEM standard form. Next, will address the issue in relation to developer slightly, because I do receive some questions about the employers and the developers' right. So what does an SPA? That's the question. What does an SPA between employer and purchaser say about forced merger? How will it affect the developer? First of all, I would like to repeat again that very much depends on the particular SPA itself. Again, forced merger is a creation of a contract. So you need to look at the particular contract, whether parties have catered for that when they were drafting the contract, when they were negotiating the terms of the contract. So for developer and purchaser, there is a standard form which we have to, the parties have to adhere to, a standard form contract, a standard form under Schedule G and Schedule H of the Housing Development Control and Licensing Regulation 1989. I've looked at both the schedule yesterday, after I received this question, and I realized that from the standard SPA provided under Schedule G and Schedule H, there's actually no mention of a forced merger clause. So I understand that a forced merger clause is usually added by the solicitor of the parties over and above the standard SPA provided under Schedule G and Schedule H of the regulation. So actually, to one extent, some forced merger clause, if there's one in the SPA, may provide that a party shall not be liable to the other party for any loss, damages, or delay whatsoever and howsoever suffered or incurred by the other party due to any government actions. So again, very much depends on your individual SPA. FAQ issued by the Ministry of Work. What sector do items L and M of critical works fall under? Let's have a look at this section, this L and M. This is yesterday's slides. I've put up in yesterday's presentation. I've listed down all the critical works that was defined by the Ministry of Works in their FAQ, in their first and second FAQ. And why this the reason why L and M is of significant is because pursuant to the second FAQ issued on the 1st of April, application for exemption for critical works by the contractor will now only be confined to item L and M. If you ask me, I think M is really broad. Other works which, if not completed, will cause harm. So it is not tied to any particular sector. Next question. If the construction works are under the purview of the Solid Waste and Public Cleansing Management Act 2007, can the contractor claim for forced merger? So from the questions that was posted by the fellow participants, I do understand that there is some concern about forced merger. Again, I have to stress that forced merger is not, there is no legal definition and it is not an automatic right. I know a lot of people are talking about the force majeure, but you still need to go back to the basic, which is the very contract that governing the parties. So the question, can the contractor claim force majeure? There is no answer because again, you have to look back to your contract. And I have to say that force majeure is an event. It is not a claim. So it is if it's provided under the contract, then you can look at your contract and see this particular event, whether it gives rise or give you right to claim for EOT or loss and expenses. It may or it may not. I've looked at PAM yesterday. PAM says yes, you can claim for EOT because there is a force majeure clause in PAM, but there is no force majeure clause under the as an event to claim for loss and expenses. Okay. Now I'll move on to the next question. Ministry of Housing and Local Government has not issued any FAQ on construction works. Can the contractor rely on the Ministry of Works FAQ instead? I think the answer is yes, because the FAQ issued by the Ministry of Work is not confined to just works that was awarded from that particular ministry. The FAQ address all construction work. So it doesn't matter if your contract works is under the purview of the Ministry of Housing and Local Government instead of the Ministry of Works. Next question. Can the notice of force majeure and notice of EOT be combined, or must it be issued separately or standalone? First, I think the answer is found in your contract. You need to look at the contract, see if there's any prescribed form in your contract which spelled out how the application of the EOT have to be. If there's none, and of course, I'm assuming that there is a force majeure clause in your contract, and unless it's specifically spelled out, the contractor that they need to submit a notice of force majeure, I think that force majeure is a ground. It's a ground for EOT and to be included in the application. So in your application for EOT, you will state, oh, this is the ground that I'm relying on. So the answer is yes. I think you have to combine these two together. Force majeure is a ground, is an event that lead to your application for EOT. What happens if parties only sign a purchase order without a force majeure clause or any other clause which deals with the current situation? I do have clients who thinks that contract you need to be is a document where both parties have to sign. It has to be a formal document and in order to amount to a contract. In law, what you need to amount to constitute a contract agreement is an offer, acceptance, and consideration. So it doesn't mean that because you just have a PO, it is not a contract. It very much depends on the facts and circumstances of the case, of course. And of course, one more thing that is very important, it is substance over form. So it is the substance of the events, the substance of the facts that is important, rather than the label that people put on it, on a particular document. So if, say, the purchase order amounts to a contract because you do have the elements of what is required of to constitute a contract, and then in this particular PO, there's no mention of force majeure or other clause which deal with the current situation. As I shared yesterday, unfortunately, I think that the general rule is that if the contract is silent, then the laws have to lie where it falls. i.e., I think the contractor will have to bear the risk and bite the bullet. Moving on to the next question. Would main contractor be allowed to claim for EOT and loss and expenses if they delay work on site due to MCO? I think the question was whether if the contractor was already late before this MCO, they were already late, and then coupled with this MCO, will they still be allowed to claim for EOT and loss and expenses? Again, I have to stress, whether or not the main contractor is entitled to apply for EOT and loss and expenses, it depends on the terms of the contract. Assuming that there is a clause for them to claim for loss and expenses and EOT, I think the question is, what if now, even before this MCO, main contractor has already delayed. So what happened now? I think the main contractor can still entitled to claim, because the fact that the main contractor is already late for this particular this particular work does not take away their right to claim for EOT or loss and expenses under the contract. I think the more practical issue in relation to this scenario is, how do you separate that this delay was the previous delay, and now this MCO caused this further delay? So how do you separate the delay and the cause of it? Because it's caused by two different events. Would a contractor be allowed to claim loss and expenses following the example of claims you have given in the slides? Yes, I have provided some example in my slides yesterday, but whether or not a contractor can claim for it, again, depends on the terms of your contract. Next question. As a contractor, our main contractor instructed us to proceed with some critical works as listed in the waiver given by JKR DOSH. How do we address EOT and loss and expenses claim? Right. So the fact that you have to carry on with your work, it doesn't mean that you were not affected by the COVID-19 MCO. Although you still need to proceed with the project because of the nature of the work, falls under the definition of critical works. And the MCO still affect you in terms of progress of work and costs incurred arising from this MCO. So go back to your contract and see if there is any terms which says that you can claim for it. If let's say what I can think of, because you don't have to confuse between suspension of work and because I suspend work, I can claim for EOT and hence I can claim for loss and expenses. Even without suspension of work, you are still affected by the MCO. And hence, with that, you of course, provided there is a clause under your contract to claim for EOT and loss and expenses, you need to just in the particular claim for loss and expenses and EOT, you need to justify how the MCO affected you. Maybe, for example, although you are working, but the rest of the world are not, and you will need longer lead time for material. Next question is, how does force majeure give employer reason to delay payment for our, i.e. the contractor's claim and invoice? Okay, so I think generally a force majeure clause is a ground to apply for EOT or loss and expenses, maybe. It depends on the terms of your contract. And the employer's obligation to pay usually ties with the SO or the architect's certification of work done. So it's a different obligation. So unless it is spelled out, again, it is spelled out in the contract that says that if in the event of force majeure clause take place, then that will change the period of honoring certificate or payment to the contractor. If there is this kind of clause to that extent, then maybe. But generally, I have yet to see this kind of clauses. The employer's obligation to pay is a separate obligation. Can the contractors claim for EOT under 23.8W of PAM, suspension of work, instead of 23.8 of PAM, force majeure, which will entitle them for loss and expenses? Okay, a few points I want to address in this this question. Number one, yesterday I have looked at in particular for PAM. I think that there is three relevant events that the contractor may use as their ground to apply for EOT, and the two of them is what has been listed here: 23.8W and 23.8A. They are not mutually exclusive. I think you can try all three, depends on the circumstances. And which will, what I have problem with this question is which will entitle them for loss and expenses. Clause 23, the entire clause 23 does not deal with loss and expenses. Clause 23 deal with EOT. Loss and expenses is dealt with in clause 24. So, and we have also addressed that, I have also addressed that yesterday. This is also in relation to PAM, referring to the intention to claim for EOT within 28 days when is the starting date to write in intention to claim for EOT, 18th of March or 25th of March. 18th of March is the commencement, 25th of March is the day the extension of MCO was announced. Okay, let's look at that particular clause in PAM. This is PAM 2006 with quantity. As I've said yesterday, there is the 2018 form is similar insofar as the extension of time clause 23.1 is concerned. This particular question deals with 23.1A. So it reads that such notice, if you is on the third line after 23.1A, such notice must be given within 28 days from the date of the architect instruction, CAI, or the commencement of the relevant event. So what 23 says is commencement of the event. I think that the start date should be 18th of March because the date of commencement of the relevant event, i.e. the force majeure, is, the MCO is on the 18th of March. So what happened now? Say if you have submitted the intention to claim before 25th of March, which is where they have been extended. When you submit on the 18th of March, let's say, you are under the impression that this MCO will end on the 31st of March. And because of that, the initial estimate might be 31st, might be 1st, but the initial estimate was based on that ground, i.e. MCO is from 18th of March until the 31st of March. But come after 25th of March, things changed and you realize that the initial estimate is no longer accurate. In that case, I suggest to write into the architect again to revise the initial estimate. So to answer that question, I think the start date should be 18, but because of the change in circumstances and the initial estimate may now be not so accurate, so do write in again to revise the estimate. The employer insists that all workers perform the COVID-19 test at the contractor's cost. What should the contractor do? I think first of all, again, you need to look at your terms of the contract, have a look at your BQ, see if the employer, whether it falls within the original scope of work. Can they impose such an obligation on you, on the contractor? So if, let's say there's none mentioned in the contract, and hence it is not the contractor's obligation under the contract, and it is just a unilateral demand and request by the employer, I would think that the contractor is not obliged to adhere. Of course, on the premise that it is not in the contract, it doesn't fall under the contractor's obligation, and it is just a unilateral demand and request by the employer subsequent to the execution of the contract. Okay, I'm done with I think I've covered most of the questions raised yesterday by our participants. I hope that all of you are happy with my answer. And we will start with the interview with John. Hi, John.
Yes, hi, good morning. Can you hear me?
Yes, I can hear you.
Okay, good.
John, we will start with the first question.
Yes.
Okay. The first question is, when the contractor gives a notice of delay after the announcement of the MCO for 14 days, from 18 to 31st of March, what should the notice state? The floor is yours, John.
Okay, now, first of all, the notice of delay, all right, have to point to a relevant event, yeah? For example, if you have a PAM contract, okay, your notice of delay has to mention the clause, yeah? The clause which gives the relevant event. For example, you have clause 23.8 under force majeure, I believe it's, let me see now.
23.8A.
Okay, 23.8A. So there's a force majeure clause there. So the notice of delay has to mention that clause, all right? And it has to mention the definition of force majeure, okay? Under clause 1, you can find that the definition of force majeure includes government action. Now, what is government action? The movement control order that was announced on 16th of March constitutes a government action. All right. So your notice of delay has to mention the clause 23.8A, force majeure, and the definition of force majeure under the contract. Yeah, clause 1, Romans AD, yeah, where it states that force majeure is defined to mean governmental or regulatory action. All right. You do not need to mention the COVID-19. Why? Because your relevant event here is not the COVID-19. Your relevant event for an extension of time is the governmental action, which is the movement control order announced on 16th of March. Okay. Now, so you need to state that, and the next thing you need to state is what is the estimate of extension of time that a contractor will need. because the MCO was announced for 14 days, therefore, your notice equally has to estimate an EOT of 14 days, all right? That is just an estimate. It may change or may not change at the end of the relevant event having ceased. So that's the answer for the first question. Shall we move on to the next one?
Sure. The next question is, what practical site operation should an employer insist the contractor do before it closes the site premise pursuant to the MCO?
Okay, now, you see, the employer here has only one concern. What's that? The employer is concerned about its works, all right, the works on the site, yeah? So before a contractor closes a site premise, the contractor has to make sure that he or she protects the works. For example, let's say there's a slope, all right? There's a hill slope, which is partly excavated. So the contractor has to put what, canvas or polythene sheets to protect the slope against the weather, against rain. That's the first thing. Second thing is the contractor has to maintain the site. Make sure that there is no clogging to the site drainage. Why? Because you do not want the site to be flooded, yeah, in the middle of the MCO period. Okay, so these are the practical site operations that the contractor has to do before it closes the site's premise, pursuant to the movement control order that orders what? That orders every private premise to be closed. You see? Now, what if the contractor fails to carry out those practical site operations? Yeah. What recourse would the employer have? For example, if the contractor fails to protect the works, let's say the works are damaged. Let's say damaged by a landslide. Why? Because the contractor fails to protect the slope from any soil erosion caused by any heavy rain. Yeah. So if the works is damaged, yeah, as a result of such failure to protect the works, then the employer has the right to insist that the contractor remedy the damage. How? For example, clear away the mudslide, reinstate the damaged works at the contractor's own cost. That is the right of the employer. You see? Why? Because that is considered a damage to the works for which the contractor is responsible. You see? So we're going to talk about insurance later because it's related to insurance. Yeah. Yep. Let's move on to the next one. So next, third question. Should the contractor notify the insurer of the suspension of the works during MCO period? Yes, the contractor has to notify the insurer. Why? Because the insurance, believe it or not, if you look at your insurance policy, especially your contractor's all risk policy, it only provides insurance coverage for the contract period, the original contract period, plus maybe 12 months or maybe 24 months of maintenance period, depending on what your contract says in respect of defects liability period. See? So insurance coverage during the suspension of the works following an MCO, yeah, for the MCO period, that insurance coverage is not automatic. I repeat, it is not automatic. The contractor has to notify the insurer, yeah, and ask the insurer, A, whether or not the insurance coverage applies to the suspension period. Yeah, the contractor has to notify the insurer. Yeah. Also, in respect of the insurer's perspective, insurer has to be updated, has to be informed, has to be kept abreast by the contractor as to what changes or circumstances that occur at the site. You see? Because any change of circumstances would definitely change the risk which the insurers undertakes to insure. All right, next question, please.
So does the existing insurance policy cover the work during the MCO period, you think, John? What do you have to say about this?
Yeah, as I mentioned earlier, the existing insurance policy likely does not cover the suspension of the works during the MCO period. You have to check what your policy says. Yeah. Generally speaking, all policies cover the original contract period plus maybe 12 or 24 months of maintenance period. Yeah. Apart from that, it does not cover any other additional periods. So you will have to notify your insurer and get them to extend an additional coverage for the suspension period arising from the MCO.
Right. Thanks, John.
Yeah. Next questions.
This one is, I think everyone's can't wait to know the answer. And we got a lot of questions on this as well. Who should pay for the contractor site overheads, i.e. site management salaries and rental of the site cabin incurred during the period of MCO?
Okay, now, again, you have to, first of all, to find out an answer. You know, I've been telling people during public seminars, to find out the answer, firstly, look at your contract. What does the contract say? You see? So you look at your contract. For example, if you have PAM contract, look at clause 24. I'm sorry to say, you'll be disappointed to see that the PAM contract in clause 24 does not provide any loss and expense entitlement to a contractor for the suspension of works during the MCO period. I'm afraid that's bad news. All right, and likewise for other contracts like PWD, IEM, yeah, they also do not provide loss and expense entitlement to the contractor for the suspension of works arising from a movement control order issued by the government. However, if your contract happens to be the FIDIC contract, for example, the FIDIC, FIDIC, the FIDIC Red Book, that means the contract for construction works. Construction works is whereby the design is under the responsibility of the employer or the owner, whereas the construction works is under the responsibility of the contractor. So under this FIDIC Red Book or construction works, it provides an entitlement to the contractor, not only for an extension of time, but also for additional cost or expense incurred during the period of suspension of works caused by the movement control order. Now, why do I say that? Because it is stated so in the clause. Yeah, if I may, I have a FIDIC contract here. Okay, I have what you see on the screen here is an extract of FIDIC contract, clause 19.4. All right, it says here the contractor is entitled to extension of time for any delay caused by force majeure, yeah, as well as any cost. You see, you can see here cost, yeah, payment of such cost incurred, yeah, as a result of the force majeure. And the definition of force majeure is very wide under FIDIC. Okay, let me show you. Okay, the definition of FIDIC is very wide. Yeah, it says here, force majeure is beyond control of a party, that means it's beyond the contractor's control, also beyond the employer's control, right? Which either party could not reasonably have provided against. That means you could not have prepared against it. Yeah, you don't, because you cannot predict the future. And you could not have reasonably avoided it or overcome it. Okay? And it's not caused by any of the parties' fault. Yeah? And force majeure here, okay, includes the following examples, but it is not limited. It is not limited to the following examples. So because of this wide definition, I'm of view that the movement control order falls under this wide definition. Why? Because it is a governmental order or governmental action or legislation that is beyond any of the parties' control, that any of the party could not reasonably have foreseen or avoided. You see? So good news, if you have a fitted contract, then you will be entitled to, the contractor will be entitled to extension of time, and as well as payment of additional costs incurred as a result of the suspension of works caused by the MCO. All right. So I shall stop here.
Okay.
Okay. So let's move on to the next question.
Sure. Let me share back my screen. Should the contractors give another notice of delay following the extension of the expiry of the MCO from 31st March to 14th of April 2020? What do you think, John?
Well, the answer is yes. All right. Why? Because you have to look back at your contract. Yeah. The contract requires you to give, the contractor to give a notice of delay or notice of extension of time claim within a certain time scale. From where? From the commencement of the relevant event or cause of delay. You see? So if you have an extension of the MCO, yeah, that is extended from 31st March to 14th April, okay, so the start of the second phase of MCO is what? Is on the 1st of April, isn't it? So therefore, contractor will have a certain time scale. If it's under PAM contract, that is 28 days. 28 days from where? From 1st of April to give a notice of delay or a notice of extension of time claim. Next question, please.
Are the contractors entitled to an extension of time of more than 28 days? Since the MCO period is only 28 days, from 18th of March to 14th of April 2020.
Yes, the answer would be the contractor is entitled to more than 28 days. Now, why is that so? You might ask. Because, you see, 28 days is the suspension of the works. I know. Why? Because the site is closed. Okay? But the contractor, in order for the contractor to close the site, the contractor will have to stop work and demobilize its machineries and manpower from the site earlier, isn't it? So you have to demobilize, you have to stop work earlier on 17 March. You see? 17 March. One day before the MCO takes effect on 18th March. What does it mean? It means that the effect of the MCO starts from 17 March. The delay starts from 17 March. And the delay will end, believe it or not, the delay will end one day before the contractor resumes works. That means, yes, I know the MCO ends on 14 April, but the contractor, practically speaking, the contractor will need 2 or 3 days or even more, yeah, to remobilize its manpower and its machineries back to the site. You see? So the time taken to remobilize back to the site, for example, it takes 2 days to remobilize on 15 April and 16 April, yeah, the effect of which is to delay the resumption of the works until when? Until 16 April. You see? So the resumptions of the work only took effect on 17 April. Yeah. So this means that the delay to the works caused by the suspension of the works pursuant to the movement control order, that delay, just to recap, starts from 17 March. That's the day when the contractor demobilized from the site, until 16 April. That's the last date on which the contractor remobilized back to the site. All right. So yes, the contractor can claim more than 28 days because that is factually correct. 28, more than 28 days, that will give you 31 days. Yeah, that is factually the effect of the suspension works.
How about, John, this question that, how about beyond that, beyond 16th of April, say because of this MCO, then it will, even though let's say on the 14th of April, let's say the MCO is lifted, okay, and we can all go back to work on the 15th of April. But the problem is that we still need more time, because there are, I think the delay is not just confined to 28 days or 30 days, because the consequence of the suspension, let's say for the raw material, it will definitely cause delay for more than that 28 days. Now that it will take so much longer to get raw materials, say from China, will that be taken into consideration when the contractor apply for EOT?
Okay, now there are two categories. All right, I see there are two categories. Firstly, there's a local delay and there is a overseas delay. All right, now the local delay means delay in the supply of materials within Malaysia. Why? Because the supply is affected by the MCO. All right. Okay. Now, because when the MCO is lifted, factories all around Malaysia will have to remobilize their manpower as well as resources to resume what? Resume production. Let's say production of cement bags, production of steel bars, for example. Okay. Or import of steel bars. Now, that will take time. Let's say the suppliers can only resume production on let's say 20th of April. All right, and the suppliers can only deliver on, let's say 25th of April. Okay, can only deliver the materials to the site on 25th April. What this means is this: the effect of the MCO is far-reaching to the extent that there is a delay to the supply of materials to the site all the way until 25th April. All right. Now, in that case, the contractor will have to carry out a critical path analysis to do what? To show whether or not the delay in the supply of the materials has caused a critical delay to the completion of the entire project or the entire works. You see?
I see. So let's say, yeah, sorry. Please continue.
Yeah, the late delivery of the materials to the site, the contractor will have to connect the late material delivery to the MCO. How do you do that? You get letters from the suppliers to confirm that because of the MCO, they could only resume production at a later date of, let's say, 20th of April. Yeah. Okay. So all these supporting documents is what the contractor will need to show a link or to show a chain of causation between what? Between the MCO and the late delivery of materials to the site. Yes, go on, please.
Okay. So I think that answer applies to also, let's say I'm a subcontractor. So after the MCO has been lifted and I'm ready for work on the first day, but because I'm a subcontractor and other area of work is not ready for me to come in to do my part. How does
yes.
that? Yeah, the site is not ready for me to go in because of the delay caused by the contractor.
Okay, so that is a different cause of delay. That's a different relevant event.
Right.
That is actually a delay caused by the main contractor, and the result of which is the subcontractor cannot go back to the site to start his work. You see? Why? Because part of that site possession has not been given by the main con to the subcon. You see? So the subcontractor will have to apply for an extension of time under his or her subcontract, if there is such a clause. Then you have to check. And the subcontractor will have to rely on the EOT clause if the EOT clause provides for an EOT, extension of time, for any delay caused by the main con. You see?
Right.
And I just remembered one thing, and going back to the earlier question, all right? Remember I've said there are two categories. Firstly is a local delay, and secondly is the overseas delay, all right? Now, with regards to the overseas delay, let's say there's a delay in the shipment of reinforced steel bars, yeah, from China to Malaysia. Okay, there's a delay. Why? Because the factories in China was under a lockdown previously, and they are taking quite a long time to resume their production. You see? So that cause of delay has nothing to do with Malaysia's MCO. No, it's nothing to do with that. That cause of delay has got to do with China government's legislation control or regulatory control or lockdown order. You see? All right. So that the contractor will have to look at its contract to see whether or not the contract has an EOT clause. If it does, the second thing it needs to see is whether the EOT clause covers any force majeure. If yes, the third thing it has to see is whether there is any definition of force majeure under the EOT clause. All right? If the definition of force majeure includes a wide definition, like what you have in FIDIC from a contract, yeah, that means a circumstance or occurrence which is outside any of the parties' control. You see? If there's a wide enough definition, then yes, it would cover the China government's regulatory control or lockdown that occurs in China. You see? So, however, if you have a PAM contract, and the PAM contract defines force majeure as including epidemic, then yes, you can link it to the epidemic in China. Yeah, because of the epidemic of COVID-19 in China, the Chinese government imposed a lockdown. That caused the production of steel bars to be shut down, and that caused a delay to the delivery of steel bars to Malaysia. So you link that. Now, you might ask a question, John, what if the definition of force majeure does not cover epidemic? It does not cover any China government regulatory control. All right. If that's the case, then so long as your contract contains an EOT clause that gives the contractor an extension of time for a force majeure event, yeah, even though the contract does not define the force majeure to include any China government lockdown, yeah, I have seen in an English case law which gives a definition of force majeure to include, number one, epidemic, and number two, government regulatory control. You see? So you can rely on that case law as to give a wide definition of force majeure, so that so long as your contract has an EOT clause that gives you an EOT for force majeure, you have to rely on that case law to say that, force majeure, there's a legal precedent where force majeure is defined to include government regulatory control or epidemic. Therefore, you should be entitled to an extension of time. Yes, any more questions?
Yeah, but John, this case law that you mentioned is the UK case law, and
Yes.
yeah, it is not binding on the Malaysian court, and it is persuasive in nature.
Yes, that's right.
So the next question is, what are the supporting documents that the contractor should submit together with his application for EOT of more than 28 days?
Okay, I've given an example where the contractor or even subcontractors have to stop work on 17 March. Even though the MCO only takes effect from 18 March, the contractor and subcontractors will have to stop work on 17 March. You see? And they will probably have to take 2 days to remobilize. You see? Remobilize. And that remobilization takes place on 15 and 16 March. Sorry, 15 and 16 April. Yeah? We have an MCO period from where? From 18 March to 14 April. All right? A total of 28 days. Okay? However, you have demobilization from the site on 17 March, and you have, for example, remobilization of resources back to the site on 15 and 16 April. Okay, so that gives a delay to the works of more than 28 days. That means it gives a delay of 31 days, 3 days extra. Now, in these 31 days, yeah, there's no work carried out by the site. Okay, and the contractor can prove this by producing photographs, site photographs. Now, the site photographs have to be dated. Okay, yes, even during the suspension of works, when the site is closed, the contractor will have a security guard stationed at the site. Okay, and the security guard can take photographs of the site gate. You see, the site gate can take photographs of the site gate that's locked. Okay, and the photograph will show a date. Yeah, will show a date where the site gate is locked. Okay, during the period of MCO. All right. So these site photographs form part of the contractor's supporting documents to prove what? To prove that not a single work is carried out at the site during the MCO period, as well as on the 17th March, one day before the MCO period, where no work is done, only demobilization of resources was done, as well as to show after the MCO expires on 14 April, as well as to show remobilization of resources back to the site on 15 and 16 of April. Okay, so you have photographs to show that. In addition to the photographs, the contractor will have to get the clerk of works or resident engineer or resident architect to witness the demobilization as well as to witness the remobilization. Why? So that the clerk of works or resident architect is able to countersign on the contractor's site daily report. That reports no work done, that reports only demobilization and remobilization of resources that was being done at the site. You see? So these are the supporting documents. All right. Next question.
Can a contractor claim for an EOT without a critical path analysis? What do you think of it?
Now, if contractor will walk up to me, John, I would like to engage you to perform a critical path analysis to claim for EOT for suspension of works caused by MCO. I would say, wait, let me check first. Yeah. I will not say yes immediately. Why? Because of this. During the period of suspension, all right, and the period of remobilization and demobilization, there is not a single work. I repeat, there is not a single work done. Okay, that means the suspension of works is 100%. If that is the case, then the contractor does not need a critical path delay analysis. Okay, why? It's very straightforward. No work is done. You don't need a critical path delay analysis. Okay. However, if the contractor were to carry out a partial suspension of works,
then go and do your thing.
If the contractor were to carry out a partial suspension of works, that means only a part of the works is carried out during the MCO period, but majority of other works are not carried out. Okay. If that is the case, then yes, the contractor will have to carry out a critical path delay analysis. Why? Because where you have only a few work that is being carried out, you do not know which of those work items fall under the critical path. And therefore, you will need to carry out a critical path analysis to determine which item of work falls under critical path and to show if there is any delay to that item of work. If there is a delay to that item of work, by doing a critical path delay analysis, you will be able to find out how much is the effect of that delay. For example, if let's say excavation of pile cap pit, all right, is being delayed, right? Whereas other works is being carried out. Okay, I don't know what other works are. Maybe welding of certain temporary strutting. Why? To ensure that there is no collapse of the partly excavated basement pit. You see, so the welding of the strutting works is carried out, or still carrying out during the MCO period, whereas other works like the excavation of pocket pit, was suspended. Okay, in this event, if you were to do a critical path delay analysis, you might find that, the excavation of pile cap pit falls under the critical path. Why? You need to have the pile cap done before your structural columns could go up, before your superstructure could go up. You see? If your pile cap is delayed, that will have a knock-on effect, knock-on delaying effect on your columns, and you have a knock-on delaying effect on your other superstructure works. So this is why a critical path delay analysis should be carried out if you do not have 100% suspension of the works. You have a partial suspension of the works. You see? And therefore, it will tell you which work is critical, which work is not.
Right.
Any question? Any more questions?
I think that's the end of the question. I've seen some, I'm looking at the chat room now. Let's see, we will just address some of the questions. I think this question from Boon is quite interesting. Contract for daily maintenance work with fixed workers. Is the contractor entitled for full payment, but there's no work? No work is carried out during this MCO. What do you think of this?
Okay, the work that you mentioned is maintenance work. All right. So maintenance work has to be carried out. If there is no such maintenance work carried out, then I'm afraid the contractor cannot claim for such work. Because if he were to claim for such work, he has to show proof that the work is done, proof in the form of site data records, even day worksheets where you will have a clerk of work to countersign, day worksheets to confirm how many laborers, semi-skilled or not skilled, are working on the site on a daily basis. You see?
Right.
Any further question?
Let's see. A few say this question by Michael. If contracts say cannot claim EOT due to force majeure events, can we use suspension of work to claim EOT and loss and expenses? This, okay. I think, John, maybe?
Sorry, perhaps the person who asked the question can explain further. This suspension of works, are you referring to suspension order issued by an appropriate or local authority?
I do not know because the chat did not mention, but I think that if, let's say we are referring to PAM, there's a reference to suspension of work under 23.8W, if I'm not mistaken. So yes. If you can't, probably the question is, if you can't rely on this force majeure clause, can we use suspension of work clause if there is a suspension of work clause in the contract to claim for EOT and loss and expenses? I think the answer is, first of all, whether, number one, the contract allow for claim for EOT and loss and expenses because of suspension of work. If yes, then the next question is whether what we are facing now, the COVID-19 MCO, amounts to a suspension of work by its nature. Let's not talk about the suspension order issued by a local authority. I think by the fact itself amounts to suspension of work. What we are facing now is a suspension of work ordered by reason of the MCO. And if the contract cater for EOT and loss and expenses by reason of the suspension of work, then I think the contractor can claim under that head. What do you think, John?
Yeah, it depends on the wording of the contract.
Yep.
If the contract says the contractor gets an EOT for any delay caused by a suspension order issued by the local authority, then it has to be a suspension order issued by a local authority. Okay? Now, if you were to look at a suspension order issued by DBKL, it will have a reference to the project site, and it will have an instruction to say stop work from what date to what date. You see? However, the movement control order, first of all, is not issued to a specific project site. Okay, it is a blanket order issued by the government or ministry to close the site. Okay, to close the site because it's a private premise. You see? Now, closing the site, yes, gives the effect of a suspension, right? But it is the wording is a bit distinct. Yeah, it is not a direct order to the specific project site to suspend the works. It is merely a blanket order to close the site. All right, but nevertheless, if you still want to rely on that suspension order, yeah, by the local authority under the PAM contract, you have to be careful because PAM contract says that yes, you can rely on a suspension order issued by a local authority, but that order must not result from the contractor's own default or negligence. You see? Does this say? Can you confirm that's what the clause says? 23.8W.
The loss and expenses clause, right? You're referring? Is the 23.8?
No, the 23.8W.
Yep.
Oh, sorry, 23.8X is 23.8X. Yeah. It says that suspension of the works by an order of the local authority, provided that is not due to any negligence, omission, default, or breach of contract by the contractor or nominated subcontractors. Yes, that's right. Yep, that's right.
Oops. Sorry, just a bit of lag. I'm trying to pull up that particular clause.
Yes, X. Sorry, 23.8W. Yeah.
Suspension of the whole
2006.
part of it.
Yes, that's right.
Yeah. So arguably, it can be yes or no. Okay, let's see what else we can. I think we run way beyond our expected time. I will now pass it back to,
Okay.
I shall pass it back to Hannah.
Thank you, Christine and John, for your insights. Thank you again, Christine and John, for your insights. Those were really helpful, and I hope everybody, I hope you found today's session informative and useful. There will be no further Q&A questions today, but if you have questions, please fill in our contact form. It's at our website, MahWengKwai.com/contact us, or email us at lawyers@MahWengKwai.com, or call us at this number. This is our number as long as MCO is in place. Please also join us next time for upcoming talks. This is the list. You'll have a talk on Monday on the rescue mechanisms for distressed companies, corporate voluntary arrangement. This will be headed by our corporate department. And then MWKA Tech will have a talk on business continuity. The show must go on. And finally, for those who are interested in Sharia law, estate planning under Sharia law, we'll have something on wasiat and hibah, which will also be presented by our partner, Sarah Kembali. You can sign up at this link or go to the events page tab on our website. So what you can do is I'll leave the screen on so that you can screenshot for the upcoming topics. Okay. All right, two more things. First, please fill in our feedback form. I will link it in the chat. And finally, follow our social media accounts. We have a Facebook, Instagram, as well as Twitter account. All right, is that cool, everybody?